Good evening. I'd like to acknowledge that Dalhousie University is located in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq. We are all treaty people, and before beginning our discussions, I would like us to pay our respects to the elders. My name is Sara Seck, and I'm an associate professor and associate dean research at the Schulich School of Law and a member of the Marine and Environmental Law Institute. I will be your host for this event. I would like to welcome all our viewers and our three panelists who we are delighted could join us for this discussion of how human rights approaches to climate litigation might help to reduce and remedy climate harms for present and future generations to come. Before I introduce our panelists, I'd like to briefly set the stage for our conversation. We are in a time of global ecological crisis, and a safe climate is essential for both present and future generations. When we speak of international climate law, we often think of the 1992 United Nations Framework Convention on Climate Change and the 2015 Paris Agreement. These international treaties adopt a technical managerial approach to the problem of climate change, clarifying state obligations to mitigate climate change, that is, to reduce or offset greenhouse gas emissions, and to adapt to climate change, that is, to adjust social and economic systems to minimize climate impacts. More recently, attention has been paid to the need for states to address loss and damage from climate change, representing an acknowledgement that human-induced climate harms will not all be avoided. While the preamble to the Paris Agreement does make brief reference to human rights, international climate law has been slow to center the impacts of climate change on people, as well as future generations. One of the earliest attempts to frame climate change as a human rights issue was brought by Inuk Shilawat Cloutier on behalf of the Inuit in an unsuccessful petition to the Inter-American Commission on Human Rights in 2005. However, since then, sources of international human rights law have gradually clarified how climate change impacts human rights and the obligations of states and other duty bearers to both prevent and remedy climate harms. Today, we're seeing an increasing number of climate cases brought all over the world, including in Canada, and increasingly, claims are framed as raising human rights concerns. With that, I would like to welcome our panelists for this evening, all of whom I've had the privilege of working with over the last few years at Dalhousie. Charlotte Hobson is a JD candidate at the Schulich School of Law. Before law school, she studied environmental geography at the University of Toronto. Charlotte is primarily interested in environmental justice issues and the uneven impact of environmental crises. She recently explored this topic in a research paper where she examined how COVID-19, the right to food, and climate change intersect. Siobhan Quigg is a graduating JD MPA student at Dalhousie University. Her interests include human rights, climate law, and legal ethics, among other things. She has explored these areas in the development of a research paper on children's climate rights and business responsibilities. She's also been involved in projects on related topics as a research assistant and as a student editor for the Dalhousie Law Journal. And third, Unwana Udo is a research associate at the Marine and Environmental Law Institute. Unwana holds a Bachelor of Law from the University of Nigeria, along with a Master's of Law from the Schulich School of Law. His research interests include climate change and human rights, climate justice, climate litigation, climate oceans governance, and sustainable development. He has held teaching assistant positions in several courses at Dalhousie University, including those with environmental protection and sustainability themes. And more recently, Unwana has been working on a multidisciplinary research project under the auspices of the Ocean Frontier Institute, involving oceans governance, sustainability, climate law, and policy, as well as the evolving participatory role of Indigenous peoples and youth in decision-making within both the climate and oceans regimes. With that, let's begin our discussion for this evening. I will first ask a few questions of each of our panelists, then we will open it up to viewers to ask questions of us. If you have questions for our panelists, please feel free to post them in the comments section online. We'll begin with a question for Charlotte. Charlotte, how has the COVID-19 pandemic motivated or influenced your research on human rights and climate change? And what did you learn?
Sorry, Sarah, I think you froze right when you asked me a question, but how did the pandemic affect my research? Is that right?
That is
yes. So,
Please go ahead.
so essentially, when the pandemic was first sort of emerging, I kept reading lots about how the pandemic was also linked with other things like climate change and deforestation and biodiversity loss. And so I was really interested to look at kind of how these bigger crises sort of intersect. And there were actually a lot of similarities that sort of came up in looking at these different crises. So one of them is that they were predictable. Both the pandemic and climate change have been sort of predicted ahead of time. So there's lots of research showing how deforestation increases contact between humans and non-human animals and leads to an increase in infectious disease. So this sort of predictability was really interesting to learn about. They're also both less costly to address at an earlier stage. And they are global, so they require global cooperation, but they're met with very nationalistic sort of responses. Um, and then as well, there were really interesting connections between these crises and the impacts they were having. So the pandemic has had a huge impact on hunger globally. It was projected that it would more than double the number of people facing acute hunger. And then even within Canada, we saw people rushing out to the grocery store, stocking their shelves, trying to prepare for 2-week quarantines, and there was no flour available. So the pandemic really brought up food as this really important thing. And I was really interested because climate also brings up some of these issues. And Sara actually sent me a news article today about how climate change is predicted to very highly worsen hunger, which is something we can tell by looking at things like IPCC reports that show the impact of climate on crop production, on fisheries, and things like that. So there are lots of really interesting connections between the pandemic and climate change. And I was really interested to see how people were sort of bringing up food in climate litigation. And it turned out when I looked at these cases of climate litigation in Canada and internationally, food was actually much more of a focal point than I would have thought previously. So it was raised by the plaintiffs in all of the climate litigation in Canada that I looked at, 4 cases from 2020. Maybe not in a huge way, but in some cases it was in a huge way. So in La Rose, it was raised by 9 plaintiffs, which is quite a large number of plaintiffs, who were talking about the impacts to crops or their potential to get really culturally important food sources like marine mammals and things like that. So you see this sort of centering of food in the climate's litigation already and internationally as well.
Thank you, Charlotte. Let's move now to Siobhan. Siobhan, many of the recent Canadian cases have been brought by youth plaintiffs. Does international law, such as the Convention on the Rights of the Child, help to support children's rights in relation to climate change? And are there any international climate litigation cases that you've found to be of interest in this area?
Yeah, for sure. First of all, thank you very much to all the event organizers for putting this together and inviting me. But yes, of course, the Convention on the Rights of the Child does have several relevant provisions. And while it doesn't plainly state that there's a right to a clean environment, there's several rights that make it obvious that states must protect children from environmental hazards and empower children to protect themselves. For instance, there's the right to life, survival, and development, health, and an adequate standard of living. And under the convention, children are also entitled to the right to their culture, leisure, and play, which are often compromised by extreme environmental changes. The right to non-discrimination and the state's obligation to act in the best interests of the child are also relevant because there's research that shows that children are more impacted by environmental harms than perhaps adults might be. And lastly, children have a right to education under the convention and information about the environment, and they must be allowed to freely express their views and have those views respected by states. So Canada is a party to the convention, so it has a duty to recognize and fulfill all those rights. But how is that actually enforced and what impact does that make? Well, the Supreme Court has held that Canadian courts don't need to enforce any part of the convention specifically unless Parliament has passed legislation that implements it domestically. However, it has said that Canadian courts can draw on the values that are reflected in the convention when they interpret statute and decide whether to review administrative decisions. And so some of the domestic cases like La Rose brought by children in Canada draw upon the convention, among other instruments, to support their claims. Beyond the Canadian courts, the convention is enforced through a reporting mechanism. So every 5 years, the Canadian government reports to the Committee on the Rights of the Child about what's been done to ensure that children can enjoy their rights. And there's the alternative reports, which are reviewed, and then the committee writes up their report highlighting successes of areas of concern. But what really interests me is the convention's optional protocol on communications procedure, often called the third optional protocol. And that allows children to submit complaints when their rights are violated and they can't find a solution at the national level. The committee also reviews those complaints and makes an assessment and recommendation. And you might have heard in September of 2019, 16 children, including Greta Thunberg, made a submission through the third optional protocol, asserting that climate harms such as rising sea levels, dangerous air quality are violating their rights, and that states are breaching their duties under the convention by knowingly causing harms, and failing to reduce emissions and failing to protect children. And the outcome of that complaint is still pending, but I'll end by noting that Canada has not signed on to the third optional protocol. So it is not an option for Canadian children to use that to hold Canada accountable. And it's a bit disappointing that Canada isn't showing leadership in this area, considering that 64 other countries have already signed on, and the Committee on the Rights of the Child and the Canadian Bar Association have repeatedly called on the federal government to adopt this recommendation. And I think adopting it would be a meaningful step towards supporting children's rights in relation to climate change.
Thank you, Siobhan. We'll now turn to Unwana. In your research, I believe you have discovered that there is a difference between adopting a child rights approach to climate litigation and litigation that focuses on the rights of future generations. Could you explain that to us and why you think it might be important?
Oh, okay. Thank you so much, Sarah. So, first of all, I do think there's a difference between the human rights approach with respect to children as it affects litigation and future generations on the other hand. Now, future generations litigation, climate litigation rather, would focus on the rights of future generations, while the children rights approach to climate litigation focuses on the rights of children. Now, on this basic surface, there is a difference. However, it's better to look at it from the point of both of them having a synergy. So both of them being mutually beneficial to each other. So while the child rights approach would adopt a very presentist approach that's focusing on people that are human beings already, that are already on Earth, the future generations approach, which has intergenerational equity as its basis, would focus on the rights of future generations. So it adopts a more futuristic approach. But the interesting thing is that both of them could benefit from each other. Now, the problem with, or one of the problems with the child rights approach, which is, of course, also a problem when it comes to the human rights approach to climate litigation generally, is the problem of proving violation. So because the human right framework is designed in such a way that you have to prove harm or threatened harm, impending harm, sort of. That's part of the obstacles that have been faced by those who have adopted the child rights approach to climate litigation. But what the intergenerational equity approach, that's the future generations approach, would do is to relieve some of that burden. So it will make it in such a way that if there is proof that there is some harm to future generations, I mean, that's very broad. It's a very wide concept, and I believe proving it is going to be very liberal. So the courts would basically be very receptive to it if we get to that point, anyways. So that approach, that's the future generations approach, would relieve some of the burden of having to prove actual harm. So all you need to do is you come forth with your climate litigation, and I mean, it should be pretty easy to prove that this in 50, 100 years time is going to be a problem. Whatever it is that we are doing is going to be a problem. And on the other hand, the future generations approach would benefit from the child rights approach because, I mean, simply because future generations are not here yet. So someone has to carry the mantle. Someone has to bear that mandate and protect their interests. So who better than the children? The children are more or less like the bridge between the present generation and future generations. So they straddle both generations. So they are like the transition between both generations. So it's important that the child rights approach to litigation, climate litigation, adopts or incorporates the future generations approach, so that the rights of future generations and the principles of intergenerational equity can be fully protected and realized. Thank you.
Thank you very much. Let's go back to Charlotte. Charlotte, how has the Canadian Charter of Rights and Freedoms been invoked in the recent Canadian climate litigation cases? And are there any other legal doctrines worth noting? And I also note, of course, there's a real important role here in terms of Indigenous rights.
For sure, yeah. So the main sections of the Charter that you'll see coming up in the climate litigation are Section 7, which is the right to life, liberty, and security of the person, and then also Section 15, which is equality rights. But there is also definitely a role for Indigenous claims within those sections, and then as well potentially through Section 35, which affirms Aboriginal and treaty rights. Importantly, though, Canada has not constitutionalized environmental rights, although 100 countries have. So keeping that in mind, the Charter arguments can't benefit from that sort of provision. And Section 7, which is the life, liberty, and security of the person, doesn't right now, at least, recognize positive obligations, which would be likely where the right to food would fit in. And so there's a case called Gosselin that says, you know, potentially this could happen. It could one day protect positive obligations, but as of right now, that's not the case. So you have to fit it into life, liberty, or security of the person. There are also cases, though, that say that international human rights law should be sort of read in with the context of the Charter. So when courts are looking at the Charter, they should, based on a case called Slate Communications, be considering the international human rights approach and how that should inform the Charter interpretation whenever that comes to court. There are also some really interesting Charter arguments in other places. So there was a really interesting case in Ontario, which some people might have heard about. It was the government imposing that gas stations had to have a sticker on all of their gas pumps that was talking about the carbon price and saying it'll cost you. And so there was a really interesting claim brought against the government saying that this was compelled speech. So it was a freedom of speech argument. So there are really interesting ways that you can bring in kind of climate-related actions through other sort of innovative routes. There was also a case where a protester was standing in front of the Trans Mountain Pipeline, and he didn't move, even though there was an injunction. And although it was unsuccessful, he argued the defensiveness, which essentially means like he needs to be there. There's imminent harm if he doesn't stop this pipeline being built. So there's definitely room for very creative arguments.
Hang on. Thank you, Charlotte. I think you froze right at the end, but we'll move on from there. I think we captured basically what you were saying. So I think we're all good.
Oh, am I frozen? I'm so sorry.
You're not frozen anymore, so we're okay. But we'll we'll come back to you in a minute, perhaps. Unwana, maybe we'll turn to you for the moment. Picking up on the comments about the right to a safe, clean, healthy, and sustainable environment, do you think this right, or recognition of this right, would be helpful for human rights-based claims? And do you have examples from other countries that we might find useful?
Oh, definitely, definitely. So, looking through the cases, one would realize that besides the fact that bodies like the Office of the High Commissioner on Human Rights for the United Nations, that office has already emphasized and released several reports on the importance of recognizing the right to a safe and healthy environment. I mean, besides that fact, so if we look at the cases, you would find that where the courts have actually upheld the human rights, where the courts have held that human rights are being violated as a result of climate unfriendly activity, you would find out that there is a common denominator in most of them. I mean, as far as I can tell, virtually all the cases where the plaintiffs or the applicants or petitioners have been successful or have gotten favorable outcomes, the courts actually recognized the right to a safe and healthy environment. So it's usually based on that understanding. That's where the court would typically proceed from. So you find that the countries too that have that right in their constitution would have the courts readily accept claims from plaintiffs and applicants when compared to the countries that do not have it. For example, in Canada. So some of the cases basically would be there's the popular Oganda case from the Netherlands, where the court at the end of the day found in favor of the plaintiffs. There's Legari and Federation of Pakistan. That's a Pakistani case. There's Future Generations and Ministry of Environment. That's a Colombian case. So these are cases where the courts have actually found in favor of the plaintiff and reached some sort of favorable decisions for the plaintiff. Now, compared to the cases that have been resolved against the plaintiffs, starting with the Canadian cases, that's the right to a safe and healthy environment, does not exist in Canada. So virtually what that causes is it creates an obstacle of proving what the cause of action is. So as much as we try to fit it into the other, the right to life, I mean, it basically touches on most other rights because there is an intersection. It's interwoven, the environment. You can bring it into virtually any right. But it's important to have a frontal approach as well, which is what I've observed as part of my research. So many of the cases, even across Europe, you have the case of Amado Cavallo and the European Parliament, Friends of the Irish Environment and Ireland. You find that in Ireland, for instance, that right is not expressly recognized. So it's one thing that you would always, you are likely to find that where a country has not constitutionalized a right, or at least recognized it by enacting statutes to protect that right to a healthy environment, the courts tend not to uphold the claims of the plaintiffs when they indirectly link the right to a safe and healthy environment to other already existing rights. I mean, to my mind and from my analysis of these cases, even though the courts may not be that intentional, but that right is always there. And it's always a topic of discussion where wherever you find that the courts would ultimately find in favor of the plaintiffs or the applicants. And even from an international perspective, I mean, that right has not been enacted yet into maybe a treaty or some sort of instrument yet. That is equally important. But the bottom line is that right is a very key piece to the human rights approach to climate litigation. And for a country like Canada, I mean, it does not just stop with codification and constitutionalization. We need to make sure that it applies across board, because putting it, for instance, in the constitution, the constitution does not, the charter, for instance, rather, does not apply to everyone. So it would be important to have it in an instrument that applies to all and sundry, everyone. So it's a very key piece of the climate human rights movement.
Thank you, Anna. Before we move on, I'll just note a reminder to encourage those who are watching to feel free to please pose questions in the chat or comment section for us to return to. Charlotte, I just wanted to make sure we hadn't cut you off earlier when you froze. Was there anything you wanted to sort of add at this point or in response to what Anwana said? And otherwise, I'll turn over to Siobhan.
Yes, I'm so sorry. My Wi-Fi has decided to cut out at inconvenient times today. The only other things that I wanted to say is you asked about other doctrines, and there is also the public trust doctrine, which I actually haven't studied, but maybe Sarah, if you know more about it, or one of the other panelists. And then in terms of Indigenous rights, I just also wanted to mention that also really important is the United Nations Declaration on the Rights of Indigenous Peoples, which there's a lot of provisions in there that could be sort of worked in well to an argument on the right to food and culturally important food sources within Canada. But other than that, I think I covered most of my points.
Great, thanks so much, Charlotte. And I think there's a really interesting conversation that we can maybe come back to in terms of the relationship between, for example, a substantive right to a clean, safe, healthy, sustainable environment. I can never get those in the right order. And of course, Indigenous rights and future generations and so on. So there's lots of interweaving that we can perhaps come back to. I will, though, at this point turn to Siobhan, because of course, not everyone believes that litigation is the answer, and although of course it may very well be and is perhaps an important piece of the puzzle, but beyond governments, I wondered if you could speak to how other sectors of society, like Canadian businesses, for example, should or could do more to proactively address climate change based on your research.
Sure. So yeah, I think the private sector is a major player, but it does make sense that many of the Canadian cases so far have been aimed at government, as there are laws that establish what government's duties are, and traditionally states have been dominant players in governing environmental issues. But today I think we have to acknowledge that businesses have taken a greater role. So the private sector greatly influences children's environmental rights, and they're unavoidably part of these governance systems now. And businesses themselves recognize that they have this role to play. I think for over 50 years, at least, businesses have found it in their best interest to make voluntary commitments to protect human rights and the environment. So for instance, there's the UN Global Impact Initiative, which is a voluntary program that has CEOs commit to sustainability goals and taking steps to support UN goals. And to date, we have over 13,000 companies participating in that. And why do businesses want to be involved? Well, not only do they have a huge influence, but there's, of course, a moral imperative. It also supports businesses' brand, reputation, stakeholder engagement, and it can make it easier to secure licenses and other competitive advantages. Also, a responsible environmental and human rights record is increasingly important to investors, which the uptake of the ESG factors demonstrate. And as you may know, the ESG criteria, or the environmental, social, and governance criteria, are the set of standards for companies' operations that socially conscious investors use to decide where to put their investment. So not only can environmental actions that are responsible attract investment, it also helps recruit talent and improve employee morale. And it also is important to this discussion because it helps mitigate the risk of litigation. So in addition to things like the global impact, there are tools that can help businesses support children's rights in respect to climate change specifically. So the Committee on the Rights of the Child has made several recommendations to provide some guidance. One of those being that businesses collect child-specific information and use preventative measures to protect children from environmental degradation and contamination. It's also recommended that states educate businesses on the unique experience of children and consider the best interests of children in all legislative, administrative, and judicial proceedings that relate to business activities that impact children. The committee also has said that businesses and states should meaningfully consult children and provide access to remedy. So in addition to the committee's guidance, UNICEF has also collaborated with the UN Global Compact and other stakeholders to develop the Children's Rights and Business Principles. And at least 5 of these principles provide useful guidance on how businesses can better support children's rights specifically. So the first is to commit to children's rights by making a policy conducting human rights due diligence that specifically considers children and providing child-sensitive processes for remedy. The second is to ensure protection and the safety of children in business activities and facilities. Third, to respect and support children's rights in relation to the environment, land acquisition, and land use, including by reducing emissions. Fourth, to aid children affected by emergencies. And fifth, to reinforce community and government efforts to fulfill children's rights. For example, by working with and not against governments who are putting forth efforts to implement environmental protection legislation. So encouraging the private sector to embrace these principles for all the reasons that they've already begun to engage with this, and the committee's guidance is another way that we can support children's environmental well-being in addition to litigation.
Thank you very much, Siobhan, for that. So I understand now that we do have some questions from our audience, and perhaps we can turn to that at this point. So here's one from Mohammed. If a state has complied with its national and international commitments, and there's some damage to people and children coming from natural disasters, does that state have a responsibility or obligation under the climate change regime, or is its responsibility coming from breach of its obligations under human rights? How can we connect these two legal regimes in this case? Is there a volunteer who'd like to speak to this? The relationship, I think a key point is what's the relationship between these different international regimes? We have climate treaties and we also have international human rights law. Might I put Anwana on the
Okay, so I think I would just like to make a point. So I think it would, the regimes for both of them, that's climate change, would cover it, as well as human rights. As much as there isn't a synergy right now between both, but that's what both regimes are working towards, a synergy. So recently, following the Paris Agreement, you find that there is an increasing recognition for climate loss and damage when it comes to climate disasters. So to that extent, I would say that there's an obligation definitely when it comes to human rights, because of course the states have the duty to protect, respect, and fulfill human rights. However, when it comes to climate change, the conversation isn't much of who has an obligation or not. I mean, we would agree that there's some responsibility for the international community, as far as those natural disasters are linked to climate change, as far as they are causes or effects of climate change. However, the way the regime is, it's more or less based on solidarity as opposed to accountability. So you find that states, with respect to loss and damage, climate loss and damage, would ordinarily not feel obligated to render assistance or take responsibility when it comes to the damage that has been suffered. So I mean, it's an area that is it's hotly debated currently, but I would say that both of them would cover it. Definitely, there is a human rights issue there, so it falls within the sphere of the international human rights regime. But when it comes to the climate regime, things are not as straitjacketed as they may seem in the human rights regime. So it would definitely fall under climate loss and damage. But just like I mentioned, the issue that we have with climate loss and damage is it's more or less currently based on a structure of solidarity as opposed to accountability. So if we have a situation where no state or the international community refuses to take responsibility, I mean, there's actually no way to hold them that accountable as you would when it comes to human rights. And that's part of the issue with climate change, because the harm is not necessarily direct, but we've all agreed that everyone should take responsibility for the harm. But why the climate loss and damage is a very hotly debated topic is because this is where we are coming down to the numbers. We are coming down to taking responsibility for the damage. And everyone is wary of doing that. Everyone is cautious of taking up responsibility for loss and damage occasioned to maybe some states and what have you.
I'll add, for those interested in loss and damage and some of these questions, my colleague Meinhard Duell and I have just co-edited a book that has not yet been published, but it is focused on climate change, loss and damage, and precisely questions of remedy within and outside the UN climate regime, including the intersection with human rights. It's very complicated, but hugely important issues. I believe we have another question or two, unless Charlotte or Siobhan want to add anything to this one.
I could just add something small, which is if people are interested in that too, on the more kind of scientific side of how do we prove that something's linked to climate change, there's a lot of really interesting studies, which I believe most of them call it attribution science, but for things like hurricanes or rising sea levels affecting people who are on coastlines and things like that, it's definitely a really big question of how do we prove that this specific event or this specific loss in crop yields or fisheries decline or something like that is linked to things like temperature increases. I think it'll become more and more clear, and the IPCC does have a lot of reports that they've done a lot of this work in, but it's a massive topic, especially when you look at these types of kind of extreme weather events, for sure.
Thank you. So an additional question, I believe, here we go, from Corey. Is there any work being done to protect the human rights of impoverished children and families who may disproportionately experience the costs of climate regulations while we work towards a better future for new generations? So for example, reducing carbon footprint by buying, eating local or vegan, which is not a choice some families can make, or the ever increasing carbon costs to companies which get passed down to the consumer. Would Siobhan or Charlotte possibly like to take that one on?
I don't know if I can say much about this. Charlotte, do you have some thoughts?
Can I see the question again? Sorry, I think I could answer a few parts of it. There are some studies, so on the increasing kind of cost to local people or just the everyday person, you do hear this a lot with things like the carbon tax, for example, in Canada. We saw a lot of arguments about how this was going to harm people who had to drive, had to travel long distances and things like that. And I think a lot of those arguments are valid. I think we also have to remember, though, that there are some reports, and I don't want to say a number in case I'm wrong, but it's a very small number of companies who are responsible for a very large proportion of climate change, climate damage. And so I think shifting the cost and the responsibility to those who are more responsible is sort of the approach that most people would sort of advocate for. And so with the carbon tax, for example, they do have the rebate for lower income, and it sort of graduates. So they try to minimize, or at least the Canadian government did try to minimize the impact on sort of lower income to middle income folk who are affected by the carbon tax. But I'm not super well versed in this stuff. So maybe, Sarah, if you have something to add as well, or correct anything I said if it's wrong.
Thanks. I think you are well spoken on this. I think I think just following up on the comment that you made, I think one of the things that I often say to my students that I sort of puzzle over in the Canadian conversation about this is that we do talk about the carbon pricing legislation as being important because it puts a price on carbon, and so this is going to change consumer behavior and do various other things. But missing from the entire conversation seems to be the question of when climate harms happen, as they do and have been for a long time, who pays to cover that? So I think there are the two dimensions for those who are living in a lower income situation. They're likely more vulnerable to climate harms as well. And so we have the question of who's going to pay to compensate for climate harms when they happen, and where is that money going to come from? And so that's a bigger conversation that we don't really have much in the Canadian context about, where do disaster relief funds come from? And is there a limit to the amount of disaster relief funds that are available to help? And I believe there's some big studies going on the potential role of the insurance industry in this area, that maybe insurance could play a bigger role. But ultimately, who should pay the costs? And we have a lot of work to do in that space. I know there's at least one more question. And so this is from Charlotte. Further to Siobhan's comments, how do responsible business conduct guidelines as a form of soft international law influence corporate action surrounding climate change? Given that the implementation of these guidelines are often not independently monitored or verified, how do we measure their impact? Relatedly, what are challenges in convincing states to regulate and enforce best practices in terms of climate change mitigation and adaptation?
So I can take this one. So Charlotte, thanks for your question. And I take your point. These soft international law and voluntary business regulation mechanisms can be criticized as ineffective, whereas others will say that it's ineffective to rely only on hard law and harsher strategies. I take the position that it really needs a combination of both. I think that soft international law and voluntary mechanisms have a powerful impact at influencing the norms to the point where they even shape what is eventually hard law. And it also has different strengths and weaknesses in terms of timeline and willingness. As we've seen with the litigation so far, there have been great successes, but there's also shortcomings that we can't ignore and that might be, compensated in part by other strategies. For instance, environmental litigation can be very costly and difficult to be successful in because of the scientific evidence needed to establish claims. In addition, especially when children are involved, there's a huge interruption to people's lives. And then there's all these other hurdles as far as admissibility, jurisdiction, like technical barriers that avoid getting to the actual meat of the claim. So that's where I think these softer guidelines and regulation can come in and fill some of those gaps.
Thanks very much, Siobhan. Any thoughts from the others? Or I believe we have at least one more question. We can continue on with our questions. Here we go. From Rohan. Do you think that the private sector needs to be more regulated with respect to climate and sustainability goals? Are corporate standards enough, especially with greenwashing? And where do we draw the line between ensuring the private sector is being restrained, but also not stifling innovation? With respect to corporations, do you think the mandate should be changed to maximizing profits insofar as they comply with ESG or some other defined goals? So that builds a bit on the previous question. I don't know, Siobhan, if you want to add anything to this, or I can offer some reflections if that's helpful. Others on the panel?
Yeah, I don't know if I can add a lot to my last answer, but if you have any reflections.
Yeah, I mean, this might be an interesting moment for me to share. This is, in putting this panel together, I was excited to bring together the participants that we have here. I'll say that there are quite a number of other students at Dalhousie and researchers involved in related work, including some work that I'm doing right now on behalf of the United Nations Environment Program, which is designed, in fact, to clarify what responsibilities of businesses should be understood to be in the climate change context. And this is research that we're undertaking on behalf of UNEP, but also with the OECD and the UNFCCC as partners. So I think there's a need to clarify what responsibilities of businesses, what responsible business conduct actually should look like, which goes to the norm shifting, the need to change what our social expectations of business are, so that we have clarity on what that is, in light of the problems of greenwashing and corporate lobbying and the difficulties of getting state legislation to actually do what we might ideally want it to do. So we often refer to this as sort of taking a polycentric approach, that all actors have to get on board, states and businesses, and we need to change our conversations about responsibility, irrespective of what sort of the dominant way of thinking about business responsibility has been in the past. So that's my intervention at the moment on this. There's a lot. It's a very complicated topic, but I think I firmly believe we need to shift how we think of business responsibility, and I think this is part of the puzzle. I think we might have another question, but I'm not quite sure about that. Perhaps not. If we don't at this point, what I was going to suggest is to turn it back to our panelists to see if they would like to ask questions of each other, or to respond in any way to anything that they've heard so far. Any takers on here?
I suppose I could ask, because both of you, I think, know a lot more about the rights of children and this. Did you look at any cases where children were bringing claims under Section 15, and sort of how does that go? Or could you speak a little bit about how equality plays into this?
I don't know a whole lot about this, but I do know a couple cases that have used a Section 15 argument, and one I know was not successful. It was the Anjou versus the Attorney General of Canada case in Quebec, and it was a class action case for youth, and that was defined as people ages 15 or 35 and under. and they were using age as the basis of discrimination there. And throwing back to what I was saying earlier about litigation being caught on challenges that don't quite get to the meat of the environmental argument, that case was dismissed on the basis of the class action group that age 25 or 35 of all people living in Quebec was not a proper or appropriate group. That's being appealed, so we'll see where it goes. And then, of course, there's the other, the recent one in Ontario that is also using a Section 15 argument, but that one is pending as well. So we don't have too much to report other than highlighting those two cases.
Great. And Juana, did you want to make a comment as well?
I would speak more generally to the rights to be treated equally. So I'm not too versed with the nitty-gritty of Section 15 as it is, but speaking more broadly. So usually the reason for the equality argument, I don't see it as one of the core arguments when it comes to litigation so far, the ones I've looked at. But within what they've actually brought, what the plaintiffs have brought within these children cases would usually be the disproportionate effects of climate change. So usually that's the basis of Section 15 and the equality arguments. But from what I recall, I think it's usually an argument that is just mentioned in passing. So they would just allude to it, but without necessarily dwelling on it. I personally think it's a very strong argument that could be made. But like I said, I think the missing piece is the right to a healthy environment. It's easy to fit in every other right once that piece is there. So it's easier to construct your arguments once you have the right to a safe and healthy environment. So things like the Section 15 right would come in more easily. Yeah, so that's what I think.
And that, of course, leads to the problem of if it isn't in your constitution, what do you do about it if constitutional amendments are really, really difficult? Now, I note that in the Anjou case, which is brought in Quebec, there is such a right in the Quebec Charter. And so that's, if that case makes it past the class certification hurdle, then there is the promise of hearing a bit more in that space. I think another sort of theme that's come up, and Charlotte and I think have talked about this a little bit, and you made some reference to it, right? But is well, Siobhan has also made reference to this, right? The procedural challenges. It's one thing to say that one wants to bring a claim, and then the question is, what is the remedy that one's seeking? Is it for stricter government action that's more in line with the 1.5 fair share goals of Paris? But what happens if it's, bringing litigation can be expensive. Those who lose may be subject to cost awards, and all kinds of other things. And Canada, I think Siobhan was noting that Canada is not a party to the optional protocol on the Convention on the Rights of the Child. We're also not party to any regional treaties on procedural environmental rights, such as the Aarhus Convention, whereas in other country contexts, such as Europe, many countries are. And so that might also change just the litigation landscape and ease with which cases can be brought, raising these issues. So that's another dimension to the challenges. Any further final thoughts? I'm not quite sure how much time we have left. I think we're getting close to our end.
Just to mention, to follow up on what you're just saying, it's one of the major challenges, the problem of standing. So like the environment case that you were just referring to yourself and Siobhan, I mean, it's something very, as much as the right we're talking about exists in the Quebec Charter, but that procedural hurdle is always a very difficult one to cross, especially because we need a rethinking of the system in terms of who can bring actions, in terms of how violations can be proved, how causes of action can be established. It needs, like the traditional systems are basically insufficient and cannot cater for most of the arguments we would be pushing forward in terms of the human rights approach. But one thing uh, is promising. It looks good when you see some of the arguments, the innovative arguments that are being brought forward. There appears to be more innovative arguments when compared to the traditional litigation styles that were being used prior to the human rights turn in climate litigation. That's referring to the torch arguments, the judicial review arguments, and all those. I mean, those were really the traditional way of establishing things when it comes to the law. But this human rights approach is a bit more progressive. So it would need progressive thinking as well when it comes to getting the courts to accept it, not just on the part of the litigants, but on the part of the court as well.
I could add something small to that.
Please go ahead, Charles.
Just one thing that we haven't really talked about, but that's quite interesting, is whether or not the courts view themselves as in a good position to address these arguments. And some of the cases we saw over the last year, the ones that tended to be unsuccessful were the ones that sort of made these very broad claims against the government, and the ones that were maybe more successful were very targeted to specific laws or specific policies. And so that might be something to watch moving forward, is sort of courts feel a little bit more comfortable when there's a more definite claim and against a definite piece of law instead of a general sort of policy argument. And that also mirrors what we've seen internationally as well. So that's something that could be added to this conversation as well.
And can I make a quick final note as well? Although I've been highlighting a lot of the shortcomings with litigation and some of the hurdles that litigants face, I do want to note that even when there aren't pure wins in the court, there are still minor wins or smaller other forms of successes that come from the litigation, whether it be the courts recognizing a certain doctrine or the publicity and awareness that comes from the press on these cases. It is all very important.
Thank you so much for your reflections. I think that's all the time that we have for tonight. And I want to thank you all very much for joining us, panelists, and want to thank everybody else as well. Thank you very much. And take care, everybody, for the evening.
Thanks, Sarah.
Thank you.
Bye-bye.